Jyoti has work and she wants to leave 10-15 minutes early, and Mr. Dweep has also requested. So let's start it. Let the people join. Generally, people join later on. So we'll start. Okay. So good evening, friends. Welcome to the another series of webinar of Mehta and Mehta as regards IBC webinar, Decoding IBC with Mehta and Mehta. As you know, this series is for the recent judgment in past 15 days. This series is to update all the IPs, lawyers, and all the relevant people who wants to know what is happening in IBC, because it's very difficult to keep track on the recent decided cases. So we are taking the series of that updated cases. So we have with us today Ms. Jyoti Singh, founder AJA Legal, and Mr. Dweep Joshi. He is a CS and practicing advocate. Welcome, Ms. Jyoti and Mr. Dweep. Thanks for your time.
Thank you. Thank you.
To introduce Ms. Jyoti Singh, she is having 2 decades of experience and she practices in insolvency, banking and finance, recovery of debt and enforcement security, corporate fraud and white-collar crime, civil dispute, corporate, commercial and shareholders dispute, media and entertainment. Her CV, her profile is so long, it will take me half an hour to read. So I'll shorten it, Jyoti, with your permission time. And she is having experience into representing before all court, including...
I think we can move to the next speaker. It's fine.
And she is dealt with the industry I mentioned. She has dealt with all courts and she is having more than 2 decades of experience. She has various awards and she was recognized latest being leading lawyer, restructuring and insolvency by Legal Era Leading Lawyers Ranking 2023. Featured in Tamil Coffee Book, Distinguished Legal Minds India 22 by Legal Era. Recognized Legal Era Ranking 22 as a leading lawyer in restructuring and insolvency. Recognized by Chamber Global 22 Dispute Resolution Mumbai. Recognized as Dispute Resolution Star Insolvency 21 by Benchmark Litigation as Asia Pacific. Ranked as a Distinguished Practitioner in Restructuring and Insolvency by Asia Law. Recognized by Chamber and Partners in Dispute Resolution, Insolvency and Dispute Resolution Mumbai based since 2015. Chamber Global Guide Jyoti Singh is a well-known in legal arena. Awarded Young Achievers Award for the year in law firm category for the year 16-17 by Legal Era. So from 16-17 continuously she is acclaiming her awards. Thanks, Jyoti, for your time. Thanks a lot for your time and effort. Thank you.
Thank you so much for this opportunity and being a part of this. Thank you.
Thanks. Let's introduce us our another panelist, Mr. Dweep Joshi. Mr. Dweep is a company secretary and a practicing advocate, registered with Bar Council of Maharashtra and Goa. He is practicing in IBC, corporate law, merger amalgamation, SEBI, all the courts, and he is also into various fields, corporate legal majority and IBC, and also on IPR, trademark and other practices. He is having experience of almost 9-10 years. Welcome, Mr. Dweep, to our webinar. Thank you for your time.
Thank you.
Thanks. So let's start. Ms. Smriti is going to give the presentation. Ms. Smriti, you can start that. The participants, if you have any question, you can unmute or put on the chat box. Thank you. And on both the panelists, whenever you want to comment on the cases, and you can very well interrupt yourself and give your views or suggestions or any comments you want. Thank you. Yes, start.
Good evening. So we are starting with the recent important judgments under the Insolvency and Bankruptcy Code 2016. So the first matter here is Tapadia Polyesters Private Limited versus Sales Tax Officer, Professional Tax Officer and another. It is a case from NCLAT New Delhi. Facts of the case are: to recover the dues of the Sales Tax Department of the state of Maharashtra, an attachment order was passed attaching the assets of the corporate debtor. The attachment order continued. However, the assets could not be sold by the sales tax department. Liquidation commenced, in which liquidation proceedings the claim was filed by the sales tax officer. In liquidation proceedings, the liquidator proceeded to issue auction notice. Tapadia Polyesters was the successful bidder who was declared in the auction. An IA was filed by the liquidator before the adjudicating authority, praying for direction to the sales tax officer to release the attachment on all three properties. The said application were opposed by the sales tax department, and the adjudicating authority by the impugned order rejected the application. Decision of the appellate tribunal was: even when there is attachment of the assets, sales tax department cannot be the owner of the assets, and the assets continued to be owned by the corporate debtor and will be the part of the liquidation estate. The adjudicating authority committed error in rejecting the IA filed by the liquidator, relying on the judgment of the Honorable Supreme Court in Messrs. Embassy Property Development Private Limited, which judgment has no application in the facts of the present case. The attachment be released by the respondent so as to take further steps in the liquidation. Both the appeals are allowed accordingly. So the next matter is Vinay Jain versus AVJ Developers, India. Can adjudicating authority defer the resolution plan approval application, holding that it can be taken only after PUFE avoidance transaction application are decided? This also is the matter from NCLAT New Delhi. Facts of the case are: erstwhile resolution professional of the corporate debtor alleging preferential, undervalued and fraudulent transactions by the suspended director of the corporate debtor. The appellant requesting the erstwhile RP to allow the appellant to register the respondent company as MSME under the MSME Act. It was considered by the COC in the 10th COC meeting by 74.3% vote. MSME certificate was granted to the corporate debtor. Resolution plan of the appellant was placed before the COC, which was approved by 72.66% vote share. Erstwhile resolution professional filed an IA praying for approval of resolution plan of the appellant. The adjudicating authority passed the impugned order directing PUFE transaction application being IA shall be heard first and plan approval application shall be heard thereafter. The appellant aggrieved by the order has come up in this appeal. Decision of the appellant tribunal was the appellant tribunal decided to go according to the following directions. The adjudicating authority shall proceed to consider the resolution plan and not to await the dispute of PUFE application. The adjudicating authority shall decide the plan approval application and shall also consider the eligibility of resolution plan, which is an issue raised by the intervener. It is open for adjudicating authority to hear and decide plan approval application and PUFE application simultaneously. In event the resolution plan application is decided, it shall be open for the RP to file an IA. Yes, ma'am.
This is very interesting thing that even though PUF is pending and the same person is applying for resolution applicant and they are allowing as allow it. It can be the complication do arise in this if it is proceeded. What is the view of panelist in this case?
You go ahead first. No, Mr. Joshi, after you.
So actually, this has been the view of many of the NCLTs have sumoto started doing this, considering that the resolution plan first be dealt with, and then simultaneously can the puff transactions be dealt later on. That goes on simultaneously. So this is basically the view taken by majority of the NCLTs now. So this is only to go in furtherance to what the court says. The court says basically.
Yeah, Ms. Jyoti, please, your view.
See, we have section 26 of IBC, which specifically says that even if there is application for avoidance transaction pending, it will not affect other proceedings, right? So CIRP continues the way it is. So it is prudent that as the CIRP continues, so the approval of resolution plan is a end result of the CIRP. And there is regulation 35A, which of course give timelines, etc., as to when the RP is required to form an opinion, when the determination is to be made, and when that application is to be filed. So those timelines have been shortened. I agree with this judgment, and in fact, as the other panelist also says, that is what the court demands, because otherwise, if we await for decisions of avoidance transaction applications, then the resolution plan approval will take a lot of time, and which is not the essence of the code. So I think if there are any resolution professionals on this webinar, then I think sooner that opinion is formed, because 35A regulation is not mandatory, that it is recommendatory, in that sense. But that this clash is not going to happen if that opinion is formed in the beginning itself and the applications are filed well in time. The issue happens that all these applications come together where there are objections to resolution plan, as well as there are avoidance transaction application and the resolution plan application. So if these applications are filed well within time, either the orders would be passed even before the stage of resolution plan approval comes. And if it doesn't come, at least it is handy with the resolution applicant, and then the resolution plan can be formed who will continue with this transactions application after the resolution plan is approved, whether the COC will take or they account for it in the resolution plan, and basically ultimately who will take the proceeds out of these avoidance transactions. So I think it's a correct decision, and if timely decisions are taken by RPs, I think this clash won't happen where everything comes together.
Okay, appreciate your view. Yeah, Shruti, please go ahead.
So the fourth point in the decision of the appellate tribunal was, in the event the resolution plan application is decided, it shall be open for the RP to file an IA seeking liberty of the adjudicating authority to prosecute the PUFE application by RP instead of SRA, looking of the facts of the present case. The adjudicating authority shall endeavor to decide the applications at an early date. Third case, Supreme Transport Organization Private Limited versus Maharashtra Airport Development Company Limited. EMD submitted against a tender for services and the tender was rejected. The EMD is not an operational debt under IBC. This matter is also from NCLAT New Delhi. Facts of the case are: the appellant has applied for a tender which was issued by Maharashtra Airport Development Company Limited. Along with tender, the appellant has also given earnest money deposit of 5 lakhs and 2 lakhs. Both the tenders of the appellant were rejected. The claim of appellant was that his EMD is not refunded. Hence, he filed Section 9 application. The adjudicating authority, NCLT Mumbai Bench 1, came to the conclusion that the deposit of EMD in pursuance of the tender notice is not an operational debt, and Section 9 application filed by the appellant has been rejected. Decision of the appellate tribunal. Present is a case where the appellant was only a tenderer who has submitted EMD along with the tender, which tender was admittedly rejected. The EMD payment by the appellant was not towards any goods or services, and the submission that an event the tender was accepted. The appellant would have provided services is far-fetched to accept the claim relating to goods and services. The facts of the present case are clearly distinguishable, and the above judgment does not help the appellant. We are of the view that no error has been committed by the adjudicating authority in rejecting Section 9 application. Appeal is dismissed accordingly. It is, however, open to the appellant to take such steps as permissible in law.
This, I believe, is a speaking order for itself. And
Yeah, it's very clear, right? Yeah.
Madras Chemicals and Polymers versus Vijay Aqua Pipes Private Limited, a Del Credar agent who has paid to principal supplier the outstanding amount due from buyer. Corporate debtor is an operational creditor. An application under Section 7 is not maintainable. This matter is from NCLAT Chennai. Facts of the case include the appellant has preferred the instant appeal against the impugned order by which the NCLT dismissed the application filed under Section 7 of the IBC by Del Credar agent of Chemplast Sanmar Limited principal against Messrs. Vijay Aqua Pipes Private Limited, the corporate debtor. The appellant had issued a legal notice to the corporate debtor stating that the appellant is the authorized Del Credar agent of Messrs. Chemplast Sanmar Limited, and further that the pursuit of the invoice raised by Messrs. Chemplast Sanmar Limited raised on the corporate debtor will reveal that the payment in respect of the invoices shall be made in favor of the appellant. Appellant had paid the amounts to the company in terms of the invoice. The amount needs to be paid within 10 days from the date of the invoice in the event of failure. The same carried interest at 21% per annum, but the appellant restricts the same to 18% per annum. In effect of the legal notice of the appellant mentions that the corporate debtor is liable to pay the sum of rupees 1,23,14,186.94 in respect of supplies made by the company on appellant's instructions. The learned counsel for the appellant praised for allowing the instant appeal by this tribunal while setting aside the impugned order passed by the adjudicating authority. Decision of the appellant tribunal, it is relevantly pointed out that in the instant case, the appellant had issued a legal notice to corporate debtor and not issued a legal notice demanding payment under Section 1 of Section 8 of the Code. In respect of the occurrence of a default, a demand notice as per Section 8.1 was not given to the corporate debtor. As a matter of fact, the legal notice was filed, the appellant was not issued in terms of Section 8.1 of the Code. Considering the spirit and tenor of the Del Credar agency agreement, this tribunal comes to a clear-cut conclusion in the instant case. The default arose in relation to supply of PVC suspension to the corporate debtor, and as such, the amount claimed to be default by the corporate debtor. The operational debt, and for the said operational debt, only an application under Section 9 of the Code will apply. As opined by this tribunal, per contra, the application not maintainable in the eye of law. Looking at from this perspective, the conclusion arrived by the adjudicating authority, holding that Section 7 application of the Code 2016 is not maintainable and resultant dismissal of the same are free from any legal flaws. Accordingly, the appeal fails. In fine, the instant comp app is dismissed, of course, for the reason assigned by this tribunal in this appeal and no costs.
So when I was reading this judgment, I was very curious to know that when the judgment is so clear, even the, the title says that there is a supply. Can we go back to that judgment? Then why there was a confusion? Why Section 7 was filed and not Section 9? Because if we go on the facts of the case, it was for supply of some goods, right?
Go to that slide, no? Facts of the case.
Correct. So,
yeah.
Yes. So, like it says, there is a principal supplier. So, I'm very curious to know as to why did they go ahead and file Section 7 when it's so clear. Then I, sort of asked my team to find the definition of Del Credit Agency. And I'll read that. I think that is probably, and it was a new concept because regularly I have not at least dealt with any such, claims. So it says a Del Credit Agency is a type of principal-agent relationship wherein the agent acts not only as a salesperson or broker for the principal, but also as a guarantor of credit extended to buyer. So probably because it had that terminology, probably, the advice would be that you go ahead and file it. So I think whatever may be the nature of that, but I think it will depend upon what is the service provided to the buyer per se. So I was very curious to know what this term is. I
This
thought
regulatory agent is liable only when the buyer defaults.
correct.
So basically, the nature of the transaction is operational. So I don't understand as to why they even intended to go on.
Yeah. Probably because of this definition, I don't know. I mean, so I thought,
basically that financial portion of giving guarantee for and on behalf of his principal. Accordingly, I think that's why he took the position as a financial creditor. But again, that financial creditor position will come if it is not a sure, it's a contingent on the event, and that's why it cannot be FC. FC means very clear cut. And again, that interest time out portion,
Correct.
the time value of money is also missing in that case. I think that is also, yeah, but interesting this term and that arrangement. Thanks. Thanks for pointing out. Yeah. Yes, Pratik, go ahead.
So the next matter is Flat Buyer Welfare Association View Solitaire Tower and others versus Dingra Jardin Infrastructure Private Limited and others. In this matter, operational creditor filed an application under Section 9 claiming appointed by the corporate debtor for carrying out the constructions and appellant claims that there are total dues of rupees 3 crores 88 lakhs 12,122. It is submitted that adjudicating authority has issued notice on the application on Section 9. The corporate debtor appeared but did not file any reply or nor contested the matter. Adjudicating authority by the impugned order finding the debt and defaulted admitted Section 9 application and appointed the IRP. It is submitted that corporate debtor neither appeared before the adjudicating authority nor brought all subsequent events, including the order passed under Section 8 of the HRERA authority. Hence, the adjudicating authority, being unaware of the subsequent development and statutory order, has admitted Section 9 application. It is submitted that as per the order of the HRERA authority passed in Section 8, the appellant has steps into the shoes of the corporate debtor and they were required to be heard before any decision is taken to proceed with insolvency. He submits that they also cannot be held liable for any past debt. The application under Section 9 was filed in the year 2021. In spite of notice issued by adjudicating authority, corporate debtor did not file any reply and apparently did not contest the proceedings. Decisions of the appellate tribunal. The subsequent events, including the order, indicate that appellant were handed over the certain towers for constructions and they have steps into the shoes of the promoters for the purposes of the project. Before the adjudicating authority, neither the corporate debtor nor the operational creditor brought all these facts into the notice of the adjudicating authority, and so the adjudicating authority, without any taking anything into consideration, the subsequent events which have bearing on the CIRP process, has admitted Section 9 application by initiating CIRP. The appellant who have been handed over the projects and who under the statutory orders have submissions which need to be looked into the adjudicating authority before passing any order under Section 9. We thus are of the view of the order impugned cannot be sustained and is set aside. However, the application is revived before the adjudicating authority to be proceeded and again in accordance with law. Appellants are impleaded to the Section 9 application and they are permitted to file their reply. Learned counsel for the resolution professional submits the CIRP process was carried for some period and expenses have been incurred. It shall be always open for the resolution professional to file an appropriate application before adjudicating authority for fees and expenses. In view of setting aside the impugned order for resolution professional stands discharged. The appeal is allowed to the above extent.
This is interesting case, but the thing that poor RP is in between, he has to again file and separately and hire lawyer to get his fees. Who will be paid and all such. I don't know in NCLT there was any cost to the applicant and CD. Actually, there should be cost because this has created unnecessary mess. If they would have discussed all the facts, this matter would have not come. Actually, there should be the cost, but that is, I don't know, it's not there.
We actually don't know. If we go back to, I don't know what is the date of that application, because ultimately sometimes we know that several years also have.
Yes, yeah.
So we don't know who to fasten the responsibility on. And less speaking is better, I think, at least historically how things have been moving.
Yeah, right. Yeah, go ahead, please.
Mr. Subhash Kumar Kundra, RP, now liquidator of Classic Bottle Caps Private Limited versus Mr. Shiv Seth. In this matter, from NCLT New Delhi Bench Code 2, it is transaction is undervalued if the corporate debtor transfers one or more assets by corporate debtor at less value of the consideration provided by the corporate debtor. Facts of the case includes it is seen that the transaction can be considered undervalued if the corporate debtor transfers one or more assets by the corporate debtor at a value significantly less than the value of consideration provided by the corporate debtor. In the instant case, ex-promoters, respondents 1, 2, and 4 routed the proceedings charges for job work done by the corporate debtor into the personal account, and the job work revenue was not credited to the books and accounts of the corporate debtor despite such conditions imposed by the sole creditor City Union Bank via their NOC. Thus, in effect, the job work performed by the corporate debtor was undervalued to the extent that it was rendered without any value or nil consideration. Further, the respondent number 1 in the email sent to the applicant or RP clearly admitted that if the amount had been deposited to the CD's bank account, the sole financial creditor, the City Union Bank, would have adjusted the same against the bank dues. Decision of the adjudicating authority in this matter was the term asset as referred to in section 45 has not been defined under IBC. The term property is referred to in section 45 under section 3 subsection 27 of IBC 2016. Hence, we conclude that the job work revenue of rupees 69.93 lakhs of CD, which was deposited by respondent number 1, 2, and 4 into their own accounts at the cost of CD and its sole creditor, the City Union Bank, is an undervalued transaction under section 45. And in terms of section 48, subsection 1, clause A of IBC 2016, we allow the payers B and C of the applicant with the interest of 10%. And direct respondent number 2 and 4 to contribute the sum jointly only to the CIRP account of corporate debtor as to be specified by the applicant or RP within 30 days from this order. The application accordingly stands allowed.
Very interesting case of undervalue. Very few cases we have where they have explained undervalue rightly. Yeah.
Saj Housing Private Limited versus Ms. Priyanka Chauhan. The decision as to whether the corporate debtor is to be revived or not is essentially a business decision and hence should be left to the COC. In this matter, the adjudicating authority admitted corporate debtor into CIRP in section 7. The COC had decided in the third COC meeting, after considering all facts and circumstances, that it was not feasible to keep the corporate debtor as a going concern and that there was no possibility for any resolution plan in the present matter, and hence with 100% voting had recommended an application for liquidation of the corporate debtor be filed before the adjudicating authority. The adjudicating authority ordered liquidation. There are 3 main issues to be faced here: whether the admission of the corporate debtor into CIRP by the adjudicating authority, while the first impugned order dated 1/11/2021 is sustainable in the eyes of law, whether the claim made by SHPL that they should be treated as financial creditor and the CIRP be started afresh with a newly constituted COC is legally tenable, and whether the adjudicating authority has erred in affirming the proposal of the COC to liquidate the corporate debtor via the second impugned order dated 4/8/2022. So the decisions of the appeal of appellate tribunal to answer the first issue. Before us, in our considered view, this is the case where all the prerequisites for filing a Section 7 stood fulfilled, and the adjudicating authority cannot be held to have committed an error in admitting the corporate debtor into CIRP. On the issue raised for starting CIRP afresh, the learned senior counsel for the respondent number 2 has contended that the appeal to set aside the admission of the corporate debtor into CIRP is not maintainable since the COC had already taken a decision. The corporate debtor was not feasible and had recommended initiation of liquidation proceedings, which has already been approved by the adjudicating authority. The answer to the second issue is, before us, we are of the considered view that in the given facts and circumstances of the case, SHPL cannot be accorded the status of financial creditor, and therefore the prayer of SHPL to reconstitute the COC does not merit consideration. Further, since the adjudicating authority has already approved the liquidation and allowed SHPL to file its claim, we are satisfied that the interests of the SHPL have not been put to prejudice. To answer the third issue before us, we are of the considered view that keeping in mind the limited powers of judicial review available to the adjudicating authority in the given facts of the case, the adjudicating authority has not committed any error in ordering the liquidation of the corporate debtor as decided by the COC with 100% vote share. For the reason discussed above, we find no reasons which warrant any interference in the second impugned order of the adjudicating authority. We direct the liquidator to continue with the liquidation process and inter alia allow SHPL to submit their claim before the liquidator in terms of the IBC and liquidation framed thereunder. The appeals being devoid of merit are dismissed, so no costs.
The issues framed here of going back to check as to whether CIRP in the first place was initiated rightly is I find no sense in, because basically the AA to decide, and if they are satisfied with the eligibility of Section 7, it is for them to consider. And also going ahead with this liquidation, we've also seen cases where post liquidation the resolution plans have been approved. So this is in furtherance to what the court suggests.
Yeah, actually, yeah, Jyoti, your view on this?
No, so my limited submission over here is that, COC's commercial wisdom is respected, at par everywhere. Now, I think there are consistent judgment after judgment of Supreme Court also, which says that there is a very limited review. But I think the only thing that COC needs to ensure is that their commercial wisdom should not breach the provisions of law. So as long as they are within the law, and it is commercially wise for them to decide, it's fine. That's the only limited point. So I think this reasserts the same point once again.
Yeah, so commercial wisdom should be in the spirit of the law, keeping the interest of all the stakeholders, and then the maximum effort to revive or to continue and get the maximization value should be properly considered by COC before deciding this for liquidation is very crucial. Actually, yeah, thanks. Yeah, next.
The next matter is Lakshmi Engineering Industries Bhopal Private Limited versus Canara Bank. Litigation in the SURFASI and DIRT does not preclude the bank to take specific remedy provided under Section 7 of the IBC. This matter is from NCLAT New Delhi. Facts of the case: this appeal has been filed against the order passed by the adjudicating authority, National Company Law Tribunal Indore Bench, by which application filed by the Canara Bank under Section 7 of the IBC has been admitted. In the present case, NPA was declared, and thereafter the adjudicating authority has noticed that in reply, the appellant was acknowledged the debt, and thereafter OTS was submitted by the appellant. The adjudicating authority has come to the conclusion that the acknowledgement in the reply as well as OTS offer makes the application within time. Application was filed. We have looked into the acknowledgement, which was in the year 2018 itself, and thereafter within 3 years, there has been OTS proposal by the appellant. Hence, the bank was clearly entitled for the benefit of Section 18 of the Limitation Act. and the adjudicating authority has rightly held that application was within time. Decision of the appellant tribunal was insofar as the submission of the appellant that bank has approached the multiple forums, including the DRT, is concerned. It is well settled that litigation in the SURFACI and DRT does not preclude the bank to take specific remedy provided under Section 7. Hence, the said submissions does not help the appellant. As far as the last submission of the appellant that the corporate debtor is taking steps for the OTS settlement, we only observe that in event any OTS is accepted, it shall be open for the appellant to file an application before the adjudicating authority for closing the settlement under Section 12A, which may be considered in accordance with law. With these observations, we dismiss the appeal.
Basically, an overriding effect of IBC.
Yeah.
So the next matter is Conquest Laboratories Private Limited versus Sanya GIC Imaging Private Limited. The use of the term default in Section 10A of IBC makes it clear that irrespective of the fact that the debt may or may not have occurred during the excluded period, but if the default in payment of such debt arose during the said period, then no proceeding for CIRP can ever be initiated against the corporate debtor for the said default according during the said period. Facts of the case is, it is to be noted that the operational creditor had sent a demand notice, the corporate debtor under Section 8 of the Insolvency and Bankruptcy Code 2016 for payment of outstanding dues, along with 18% interest per annum. That is the amount in default. It is pertinent to refer to the agreement as entered into between parties as per clause 4, subclause 3 of the said agreement. The corporate debtor is liable to pay the outstanding amount within 30 days of raising of the particular invoice. While going through the reply filed by the corporate debtor, it has come to our knowledge that there were certain other invoices also which were issued by the operational creditor during the period excluded according to Section 10A of the code. The operational creditor was neither mentioned about such invoices in its application nor in the demand notice. However, has placed reliance on the invoices issued during the said excluded period for meeting the threshold under Section 4 of the code. Additionally, the operational creditor has nowhere in its rejoinder denied the existence of invoices raised during the period falling under the purview of Section 10A of the code. It is pertinent to mention that no person shall be permitted to approbate and reprobate at the same time. The contention of the operational creditor that the debt occurred during the 10A period shall nonetheless be counted as a debt is not denied. Decision of the adjudicating authority. In case of any default amount as claimed before, if the part default occurred during the period excluded under Section 10A to initiate CIRP against the corporate debtor, then the whole of the claim shall be liable to be discarded, irrespective of the fact that by taking out the invoices which shall fall under the excluded period, the claim otherwise fulfills the minimum threshold limit of ₹1 crore. Additionally, we are of the view that the operational creditor has manipulated the date of default to meet the threshold limit of ₹1 crore by significantly omitting the invoices falling within the period covered under Section 10A of the code to be placed before us, yet claiming the debt on the basis of such invoices. We are of the considered view that such action on part of the operational creditor is a prima facie indicative of the malicious initiation of proceedings for the purpose other than for resolution of insolvency. Therefore, having considered the facts and circumstances of the case as discussed above, we hereby, in exercise of our powers within Section 65 of the IBC 2016, it fit to impose a penalty of ₹2 lakhs only on the operational creditor, which shall be deposited in Bharat Kosh within 2 weeks from today. An application accordingly stands dismissed.
A very fitting order, I believe.
I have much to say on this order, frankly. Not the facts of this case, but I think like it was decided by Supreme Court in this Ramesh Camel matter in 2021 itself, right? What needs to be seen is that whether the default within this prohibitory period is the first default or it's a continuing default. The difficulty will be how will you segregate, meaning by, for example, if you don't meet the threshold of 1 CR and almost say, for example, 80 lakh is due before, and then this continues, right? which makes it 1 CR, then you exclude this and then subsequent
Yes.
also there is a default. How do you match this? Have you come across any such case? Because I have come across and I have much to say on this. Yeah.
And there is a clarification required for this point of view in order, because the clarification on the 10A say that can never be initiated by any application. But looking at an individual point of view is not the correct interpretation as well.
But as per my understanding, what it is that any before that period, that restricted period, and after that only they are considering, an in between period, they are not calculating at all as if there is no transaction. That way they are counting, and then pre and post that period they add and then it work out. That is the way NCLT is looking.
I actually don't have occasion to see any such. Probably I'll speak to you offline, because in one of my matters, it went south while the default was already there. But, in, like, for example, there are 5 facilities availed. Now, in those 5 facilities, in 4, there was already a default. In one of the facilities, the default period was this prohibitory period. So I think not very clear interpretations are given, to such
I
things.
think the intent of the buyer needs to be, considered at point of view where these series of transactions have been, occurring.
Yeah, in the case of series of transaction, as you rightly mentioned, complications on the facts of the case and the documents are very complicated, because many times invoices are not raised, payment is not connected to the invoice. So that all practical difficulty comes, and there actually implications on the decision comes.
No, but this is section 9. I am even talking about section 7. This is 9. I am talking about 7, where there are defaults that were continuing under 4 facility. One fell due during that time. It's not very clear. I think this law needs to, and still there will be historic cases that still need to reach NCLAT or Supreme Court. So let's see. What is clear is that if it is a first default during that period, then of course you can't initiate, anything on that. But what if it's not the first, and it is just one of the defaults, continuing defaults?
Right. Yes, Jyoti, correct.
So we go on the next matter. Kulvinder Singh Makhni, ex-director Punjab Basmati Rice Limited versus Mr. Sanjay Kumar Agrawal, liquidator of Punjab Basmati Rice Limited. Suspended director has no vested right to recommend the removal of the liquidator. NCLT Chandigarh bench. Facts of the case. The applicant stated that the liquidator has concealed material information from the IBPI as well as this tribunal regarding the registration involving criminal conspiracy, cheating, forgery, using forged documents, etc., causing wrongful loss to the tune of rupees 26.16 crore to complainant Union Bank of India, GTBH branch, Ludhiana. As per FIR, the liquidator has been named accused suspect by CBI. FIR was registered against the directors and guarantors of the company, that is Messrs. Supreme Tex Mart Limited, including the liquidator, on the basis of the Special Investigation Audit Report conducted by Messrs. KPMG India. The applicant has also filed a complaint against the liquidator before the IBPI, and the same is also sent to SCC member of the corporate debtor. The same comes under the definition of the misconduct. The liquidator stated that the contents of the instant application filed by the applicant ex-director are false and misleading. The liquidator has completed the sale of assets and properties of the corporate debtor by the way of composite sale is an e-auction. Decision of the adjudicating authority was, in the case at hand, the applicant's suspended director has made certain allegations against the liquidator in view of the aforementioned regulation 31A subsection 11. The power to remove the liquidator lies squarely with the stakeholder consultation committee. We observe that the suspended director has no vested right to recommend the removal of the liquidator. We have also gone through the IA filed by the SCC. It nowhere recommends the removal of the liquidator and has only prayed for directions to the liquidator to immediately distribute the amount recovered by him from the sale of liquidation of assets of the corporate debtor after retaining the disputed amount with respect to his alleged liquidator fee plus liquidation expenses. In view of such facts, the prayer made by the applicant is dismissed and the IA is disposed of accordingly.
one of the few frivolous applications filed by the angered ex-management.
Right. Yes.
Next matter goes to Hari Vittal Mission versus Ravi Sethia, RP of Swasth Healthcare Foundation. Section 53 of IBC does not treat the related party as a different. Facts of this case are: applicant is admittedly a financial creditor of the corporate debtor who had filed a claim of rupees 63 crores 16 lakh 33,563 with the interim resolution professional of the corporate debtor. However, the claim of the applicant was partially admitted by the interim resolution professional. Applicant was declared as a related party of the corporate debtor by the resolution professional. The applicant duly filed an application challenging the illegal and unlawful declaration of the applicant as a related party of the corporate debtor before this adjudicating authority. Resolution plan so submitted by respondent number 2 has been approved by the committee of creditors, and an application under section 30 subsection 2 of the Insolvency and Bankruptcy Code 2016. Applicant states and submits that the resolution plan submitted by the respondent number 2 presumably discriminates between the applicant, financial creditor, and other financial creditors. Decision of the adjudicating authority, the COC will be at liberty to consider any other proposal, including that of resolution applicant and IA, on the basis of its viability, feasibility, and merits. IA shall be put back on board for considering along with the revised distribution, if any. Since IA has been preferred seeking intervention in terms of the order passed in the IA, we feel that no separate order is required to be passed in this application. This order will accordingly govern all three IAs with the aforesaid directions. All the IAs accordingly stand disposed of.
So what I'm not clear in this judgment is, did the NCLT say that the related parties cannot be treated differently, or did it say, did not interfere with it, is what I am not clear in this, because they said that revised distribution will be put. The reason I'm asking is, and whatever this judgment, if it has intervened and said that they cannot be treated differently. In fact, in Appu Hotel's judgment of Supreme Court, which came in May of 2023, because NCLAT decided earlier also that you can't distinguish between any party on the basis of related party per se. There is the judgment of Appu Hotels of Supreme Court, which said that there is no provision in the code which mandates that related party should be paid in parity with unrelated party. So long as the provisions of the code and CIRP regulations are met, any proposition of differential payment to different class of creditor in the resolution plan is ultimately subject to commercial wisdom of COC, and no fault can be attached to the resolution plan merely for not making provision for related party. So I think, I don't know the facts of this case, but I guess because Appu Hotels came, and when recently I was in one of the matters, looking at this aspect, then at that time Supreme Court didn't come. So I mean, yes, I mean, if it is a classification which you can justify in terms of the code, then you can do it, is what I understand from the Supreme Court judgment.
This has a more contradicting view as to what has been upheld in the Supreme.
Yeah, but the thing that if the commercial wisdom of the COC and the resolution plan approval and the treatment of creditors, how it should be, of course, related party cannot be discriminated because of related party, but if resolution plan says and allow it, and if COC approves, I think, I don't know, it will be allowed as that as a commercial wisdom, that if a related party creditor is treated differently than other creditors in the same class, will it be correct even if COC approves?
Not according to me, because ultimately, if, for example, related party is an unsecured, so you can't be put in a disadvantageous position just because you're a related party.
Related party.
Yeah, but then it needs to be seen, because in some cases it is being done, right? And this Appu Hotel Supreme Court judgment needs to be seen in that light. But for example, if there is nobody in that class, okay, for example, it doesn't happen, but for example, there are no unsecured creditor per se, and related party is the only unsecured creditor, then can related party go on that basis? I mean, it needs to be viewed from facts to facts, but they can't be discriminated merely because they are related party. But as I said, the Supreme Court judgment at least says that there is no such express provision in the code which says that they can't be treated differently as long as they are able to justify that why this separate class is created.
Although what is related party provisions are always used to their advantageous position. If they are willing in that very situation, if that is advantageous to that, then they can go ahead with that. But then that clarification needs to be there from any other cases.
Yeah. And very interesting point, Jyoti, you mentioned that if they are the only creditor of that class, then you cannot say they are discriminated. Because you can compare with other creditor of the same class and then say I got a discriminatory treatment because I am a related party. But if only related party of that class creditor, then it is a challenging. Then it cannot be termed as a discrimination. That is a really interesting point. Yeah. Yeah, Shruti, go ahead. Sorry, I think there is a question in the chat box that is there any legal or regulatory provisions that are relevant in determining whether discrimination exists in the resolution plan?
There are no regulatory provision as such where it exists, as in I didn't get the question.
So basically all creditors should be treated equally of the same class. There's a decided cases which basically provides that same no disparity in distribution because each class, its waterfall has its own class and it should be in a parity.
Yeah.
Because I think 1653 do not discriminate, so you cannot discriminate as such. Right, Jyoti?
Agree. I think it is in series of the judgments of Supreme Court, and of course it stems from the provisions of the IBC as well as CRP regulations concerning the approval of resolution plan per se. So if we read it along with those Supreme Court judgments, I think you're
So
Yeah.
more on the judgment, and then judgment is also basically section 53 is a crucial where it is no discrimination in the classes they are allowing. So it is of course resolution plan is freedom, but it is based on the decision only, no legal provision as such. Yeah, thanks. Shruti, go ahead.
So we go on the next matter of COC of Tamra Dhatu Udyog Private Limited versus Messrs. Mehta, Binani, RP. Can COC allow all resolution applicants to enhance their plan with an object of maximization of value of assets? Facts of the case are, to clarify the order to the extent that all the resolution applicants may be given a last opportunity to revise their resolution plan, so that equal and fair opportunity may be given to them to submit a revised resolution plan. Direction to the RP to cancel the ongoing voting on the resolution plan and to conduct fresh voting on the resolution plan post submission of the revised resolution plans. The issue that cropped up for determination is whether the COC can be permitted to go ahead with its decision to allow all the PRAs to enhance their plan with an object of maximization of value of assets. The RP has permitted the PRAs to enhance their plans financially, and whether such enhancement would be violation of Regulation 39(1)A of the IBBI CIRP Regulation 2016 is question to be considered. Decision of the adjudicating authority. The instant application is filed by the COC of the corporate debtor. We are mindful of the objective of the court and the commercial wisdom of the COC being of paramount importance. Hence, we allow this application and allow all the participating resolution applications by giving a last, equal and fair opportunity to submit their revised and or enhanced resolution plans to RP of the corporate debtor. If we require fresh timelines, may be provided to all the participating resolution applicants and who wish to enhance and to revise their resolution plans Keeping in view the prescribed timelines of completion of the CIR process, and voting period may also be extended if necessary. No written submissions has been filed by any of the parties, as the court provides that the CIRP is a time-bound process. We are passing this order accordingly. The matter is disposed of in terms of above order.
Yeah, good. They have clarified this, so even the RP knows that at the end, again, they can give a last opportunity to everyone. This is also something new happened, and they allowed, not taken as a. They acted very fast and decided it fairly.
So,
Yes.
we are on the next matter. Hiren Valiyakil Lal versus KV Shriman. 3/4 resolution of partners is not made, and statement of affairs proves a favorable position of business. LLP winding up petition will essentially fail. NCLT Kochi bench. Facts of the case are: this application has been filed under Rule 11 of NCLT Rules 2016 by Mr. Hiren Valiyakil Lal and others who are respondents 2 to 5. And main petition against petitioner and other respondents in the main petition seeking to dismiss the main petition on ground of its maintainability. Hardole Enterprises LLP, the second respondent herein, was incorporated with a total capital contribution of rupees 50 lakhs. The applicants, including respondents 1, 3, and 4, are partners of the LLP. The main company petition is filed seeking to wind up the second respondent under Section 63 and 64F of the LLP Act 2000. Applicants state that the main petition is not maintainable as per the requirements laid down in the Rule 26 or subsection 4 of LLP Rules 2012 is not complied. Further plea is taken by the applicant on ground of res judicata. It is stated that the third respondent, who is the son-in-law of the petitioner, first respondent, had earlier filed this before this tribunal for winding up of LLP with the same cause of action and facts as to dispute and similar reliefs. It is stated the earlier CP was withdrawn by the third respondent without liberty to pursue the legal remedy. Decision of the adjudicating authority. In this case, it was dismissed as withdrawn by the petitioner, who is the son-in-law of the petitioner in the present company petition. On pursuit of the facts and prayers concerned, it is seen that the present petition and the previous petition has the prayer to wind up the tribunal under Section 63 and 64 of the LLP Act. However, the previous CP was withdrawn without any liberty to petitioner to rejet it again. Circumstances being so, at this maintainability stage, it is also acknowledged that the main petition needs to be heard to decide whether new facts have been emerged warranting admission of winding up of the LLP, as the previous petition was withdrawn by the petitioner and not adjudicated or decided finally on merits. It is also observed that the statutory scheme in winding up process under this provision provides the LLP to get the chance to defend the proceeding against winding up. If the fourth resolution of the partner is not made, the statement of affairs proves a favorable position of the business. The winding up petition will essentially fail. Hence, at the early stage, it is felt that the petition needs detailed hearing for deciding whether it is a fit case for admission to winding up. As far as maintainability is concerned, the petition is in order as per provision of LLP Act and rules. This application is dismissed and disposed of accordingly. List the main petitions for further consideration are mentioned.
Requirement is not met, so that's why they are, yeah.
So we go on the next case. Anurag Verma, resolution professional. Provision of CIRP regulation 36A 4A. The invitation for expression of interest, which has already been issued, can be modified only once, will not be applicable to the case dealing with fresh publication of Form G. This is from NCLT Chandigarh bench. Facts of the case. It is prayed by the applicant to grant the permission to publish fresh Form G with the revised eligibility criteria for invitation of expression of interest from the prospective resolution applicant. The said Form G was published in the newspapers and 5 PRAs submitted their EOI. As no resolution plan was received, the Form G, published with the revised modified criteria as approved by the COC in its 7th meeting held on 25/1/2023. After the publication of revised Form G, 8 PRAs submitted their EOI with the applicant did not receive any resolution plan till the last date for the submission of the resolution plans, even after extending the timelines. The applicant had discussion with various stakeholders, and it is appraised by the applicant that if the criteria for the submission of resolution plan is relaxed, then there will be a possibility of getting a viable resolution plan. In the 10th COC meeting, the revised Form G with modified eligibility criteria was approved with 100% voting. Decision of the adjudicating authority in this matter was that in the present case, the modification as outlined in para 4 behind above are not minor modifications but are quite substantial and change the nature of Form G. Keeping in view the ratios of the aforementioned judicial decisions, we are of the view that in the present case, the prayer is for republishing of Form G. As per the provisions of the Regulation 36A4A, the invitation for expression of interest, which has already been issued, can be modified only once. However, the said provision will not be applicable to the present case dealing with the fresh publication of Form G. The resolution professional is therefore to publish fresh Form G with the revised eligibility criteria for invitation of expression of interest from the prospective resolution applicant. The same may be done within 15 days of this order. In this result, IA number 1592 of 2023 is allowed and disposed of accordingly.
Yeah, rightly mentioned to take it. By the way, thanks Jyoti for your time. Friends, she has to leave because she is occupied with preoccupied decided meeting. Thanks Jyoti for your time. Thanks.
Thank you so much. Thank you so much.
Yeah,
Thanks everyone.
Yeah, thanks. Now, as regards this case, it was that since the modification was not minor but major and substantial, we changed the nature of G. They asked to send a issue phrase G, which is correct way of doing it, right? Dweep?
Yes.
Yeah. Shruti, how many cases are there? Still more?
More 2, 3 are left. 3 are left.
And that's all?
And we have DC orders also, contraventions.
How many?
2.
2. We can, Mr. Dweep will continue. You will available for at least another 15-20 minutes. We can wrap.
Or else we can take up DC matters if that is okay.
Yeah, I think that will be straightway take DC matter instead of these 2 cases. These 2 cases balance we will take next time and take DC matter straight. Okay. Yeah.
Okay, so we'll start with DC orders. This order disposes of the show cause notice issued to IP, who is a professional member of Indian Institute of Insolvency Professional of ICAI and an insolvency professional registered with the Insolvency and Bankruptcy Board of India. Contravention, charging of excess fees. IP had admitted of having charged excess fees as liquidator as per Regulation 4(3) of liquidation regulation by calculating first 6 months from the date of receipt of first tranche of sale proceeds of assets instead of from liquidation commencement date. It is further noted that he admitted of having refunded the excess fees after being pointed out by the board. Thus, IP had charged excess fee as liquidator in the liquidation of corporate debtor 1, 2, and 3. And only after being pointed out by the board, he refunded the excess amount to the liquidation account of the respective corporate debtors. Submissions, IP submitted that as against the fee calculated and charged by him, the DIR pointed out the discrepancy in calculation of fee charged by him and termed the same as excess, and that he agreed with the view of IA with respect to provisions and explanation of Regulation 4, wherein the first 6 months should be reckoned from the page 4 of 6, date of commencement of liquidation process date as against from the date of receipt of first tranche of sale proceeds of assets, as was misconstrued by him. He submitted that in view of this, he admitted and accepted the finding of the IA. He submitted that it was purely an error of understanding of provisions and not due to any intention of negligence on his part to overcharge the CD in any case or under any circumstances. He submitted that the charge of receiving excess fees and refund of the same only after it was brought to his notice through the DIR was overstated. Analysis and findings. Since the provision of Regulation 4.2 of liquidation regulation are unambiguous, the contention IP is not tenable. After the DC hearing, submitting proof of refund of excess amount drawn, and it was reported by him that out of excess fee charged amounting to rupees 17 lakh 88,468 only, he actually received excess amount of rupees 1 lakh 24,102 and 6,19,133 only, and no amount was received for corporate debtor 2. And on getting the same pointed out by IA, IP refunded the excess amount withdrawn to the account of the CD1 and CD3. Contravention of charging excess fee is established, and had there been no inspection and finding by IA, the stakeholder would have been put to loss. Order. The DC, in exercise of the powers conferred under Section 220 of the Code, read with the Regulation 13 of IBBI, Regulation 17, and Regulation 11 of the IBBI, hereby imposes penalty of rupees 1 lakh on IP, directs him to deposit the penalty amount directly to the Consolidated Fund of India under the head of penalty imposed by IBBI within 45 days from the date of issue of this order, and submit a copy of transaction receipt to IBBI.
Proceed, go to next slide, straight.
Okay. So the contravention 1, irregularity in appointment as RP. IP has recorded the minutes of first COC meeting by intentionally misrepresenting the facts with malified intention. Mr. Vishwanathan Sanskaran further continued with misrepresentation by filing a memo before the A intimating it about his appointment as RP, even though no such resolution can be said to be passed, in view of denial of the Canara Bank to have voted in favor of this resolution. It is also noted that he did not pay any heed to the request of Canara Bank to convene second meeting of the COC, which he was bound to do. The submissions were: IP submitted that 2 orders passed by A, along with the allegation in the SCN, are presently under appeal with Honorable National Company Law Tribunal, Appellate Tribunal, Chennai Bench, and are therefore sub judice. It follows, therefore, that the observations and the conclusions drawn therefrom of the SCN are incorrect, and there is therefore no violation of section 22 3A of the code. It also follows that the first COC meeting is valid, and in order he was duly appointed as a resolution professional in that meeting, and he was entitled to the remuneration and expenses as approved in the meeting till the time of his handing over charge to the new RP. Analysis and findings. The DC notes that the above said order of the AA involving the appointment of RP is under challenge before Honorable NCLAT Chennai Bench in appeal by IP. Hence, the DC refrains from intervening in the matter at this stage. Contravention 2, failure to convene.
Just for this part, where the clarification with regards to his appointment was challenged and everything, the IBBI expects the IP to continue, the RP to continue the duties as mentioned in the court. So I don't understand why is he not being, bound to collect those remuneration or whatever it is. So I believe whatever he did as a representative the current RP for the debtor was right in his view.
Okay, thank you. Thanks for you.
Contravention 2, failure to convene COC meeting as per Regulation 18 of Extant CIRP regulation. One of the FC's Canara Bank with 84.6% voting share, vide a letter dated 26/4/21, requested IP to conduct the next COC meeting at the earliest. The IP failed to consider the request of the FC, but also conducted the second COC meeting after a substantial elapse of time. Submissions. IP submitted that there is no request made by Canara Bank in their letter to convene a COC. There has been no substantial elapse of time between the first COC and second COC meeting. He further submitted that for an allegation to be made by the board of any violation on his part in not acting upon a request made by a COC meeting to convene a COC meeting under Regulation 18, such a letter has to be produced in evidence and the letter has to be from the authorized representative of the FC COC member. Analysis and findings. The DC observes that by not adhering to the request of FC to conduct meeting, IP has violated Regulation 18 of CIRP Regulation, clauses 1, 2, 13 and 14 of the Code of Conduct. Contravention 3. Violation of the AA's order. The AA passed an order directing the resolution professional to hold a COC meeting by next week and submit a resolution immediately. It is a duty of IP to abide by the orders passed by the adjudicating authority in its letter and spirit, and his conduct of convening COC meeting with a delay even when the order of the AA was explicit in its directions. Submissions. He submitted that there has been no delay. The COC meeting was called for on the day the order was received. The actual meeting could not be held earlier due to prior engagement of the COC members and the Dashera holidays. Analysis and findings. The DC notes that the IP was present before the AA while order for conducting COC meeting by next week was passed. Hence, it may be said that he was aware of the direction of the AA. In light of above, DC is inclined to take a lenient view. Order. The DC in exercise of the powers conferred under Section 220, subsection 2 of the Code, read with Regulation 13 of the IBBI, Inspection and Investigation Regulation 2017, hereby suspends the registration of IP for a period of 1 year.
Oh,
1 year was a bit strange.
1 year, yeah. Yeah. Yes, Smriti. That's all?
Yes, ma'am.
Okay, Smriti, you can stop sharing. Thanks a lot, Smriti, for your presentation. Thanks, Mr. Dweep, for your time. Ms. Jyoti has discontinued because he had a prior engagement. Thanks, participants. Thanks for all your time. Thanks, everyone. We'll come with the next session in another 15 days. Thank you. Thank you. Thank you, Mr. Dweep.
Thank you. Thank you so much.